Today we are going to talk about the international conventions which protect the intellectual property rights. One such major conference was the Paris Convention of 1883. So the Paris Convention 1883 or International Convention for the Protection of Industrial Property. So as the name suggests, this was one of the first conferences जो कि protect करती थी various forms of industrial properties. So it came into force on 7 July 1884. It has been revised 6 times since then, latest being in Stockholm, 1967. This convention is administered by the World Intellectual Property Organization, that is WIPO. Convention का Article 2 and 3 deals with the concept of national treatment. So national treatment basically means कि आप जो प्रोटेक्शन अपने नेशनल्स को दे रहे हैं विद रिगार्ड टू द इंडस्ट्रियल प्रॉपर्टी, वही प्रोटेक्शन आपको बाकी मेंबर स्टेट के नेशनल्स को भी देना होगा. दिस टर्म नेशनल इंक्लूड्स बोथ द नेचुरल पर्सन एंड द लीगल एंटिटीज. और ये जो प्रोटेक्शन है नेशनल ट्रीटमेंट की, दिस इज अकॉर्डेड टू बोथ द मेंबर कंट्रीज एंड द नॉन मेंबर कंट्रीज. अगर आप एक नेशनल है ऑफ द नॉन मेंबर कंट्री, तो आपको ये प्रोटेक्शन तब दी जाएगी इफ यू आर डोमिसाइल्ड इन द member country and you have a real and effective industrial or a commercial establishment in that member country. ये रूल इंश्योर करता है कि कोई डिस्क्रिमिनेशन ना हो with respect to the nationals of other member countries. Next provision is right of priority. राइट टू प्रियोरिटी का ये मतलब है कि अगर आपने किसी एक मेंबर कंट्री में प्रोटेक्शन के लिए अप्लाई किया, आपने या आपके सक्सेसर इन टाइटल ने, तो विद इन अ स्पेसिफाइड पीरियड जो कि अंडर द पेरिस कन्वेंशन दे रखा है 6 to 12 मंथ्स, तो 6 to 12 मंथ्स के अंदर आप बाकी की मेंबर कंट्रीज में भी उस प्रोटेक्शन के लिए अप्लाई कर सकते हैं. जब आप इस प्रोटेक्शन के लिए बाकी कंट्रीज में अप्लाई करेंगे ऑन लेटर डेट्स, तो ऐसा माना जाएगा कि वो जो लेटर एप्लीकेशंस है वो उसी दिन फाइल हुई थी जिस दिन आपने फर्स्ट एप्लीकेशन को फाइल किया था. सो दिस इज गिवन अंडर आर्टिकल 4 ऑफ द कन्वेंशन and the time period specified is 6 to 12 months. तो बेसिकली जो आपकी लेटर एप्लीकेशंस है उनको प्रियोरिटी स्टेटस दिया जा रहा है. ये जो लेंथ ऑफ प्रियोरिटी है दैट इज 6 to 12 मंथ्स, इट डिफर करती है फॉर वेरियस इंडस्ट्रियल राइट्स. जैसे कि फॉर ट्रेडमार्क्स इट इज 6 months एंड फॉर पेटेंट्स और अदर यूटिलिटी मॉडल्स इट इज 12 months. The next provision is common rules. There are various common rules that have been given under the Paris Convention, one of which is independence of patents. Independence of patents is given under Article 4 bis. So independence of patents means that कि अगर आपको एक कंट्री में पेटेंट ग्रांट हो गया है, तो उस बेसिस पे आपको दूसरी कंट्री पे भी पेटेंट ग्रांट हो ऐसा ज़रूरी नहीं है. इट डजंट ऑब्लाइज द अदर कंट्री मेंबर्स टू ग्रांट यू पेटेंट. दिस इज बिकॉज द नेशनल एंड द एडमिनिस्ट्रेटिव प्रैक्टिसेस इज डिफरेंट फ्रॉम कंट्री टू कंट्री. तो इसलिए हर कंट्री आपकी एप्लीकेशन को उसकी मेरिट्स पे जज करेगा. तो अगर एक कंट्री रिफ्यूज़ भी कर देता है आपको पेटेंट देना, तो इसका मतलब ये नहीं है कि बाकी कंट्रीज़ भी रिफ्यूज़ कर देंगी. वो आपकी एप्लीकेशन को उसकी मेरिट्स पे चेक करके फिर आपको ग्रांट या रिफ्यूज़ करने का डिसीजन लेंगी. नेक्स्ट सच रूल इज राइट ऑफ द इन्वेंटर टू बी मेंशन्ड. It is given under Article 4 term. So according to this right, कि अगर आपने कोई इन्वेंशन किया है तो आपके पास राइट है कि उस एप्लीकेशन में आपका नाम मेंशन हो. In fact, many countries require the inventor to be the applicant himself. In fact, many countries require the applicant of the patent to be the inventor himself. For example, USA. So इसी वजह से there is a pertinent issue right now. In fact, many countries require the applicant of the patent to be the inventor himself. जैसे कि यूएसए. एज वी नो दैट आर्टिफिशियल इंटेलिजेंस इज इवॉल्विंग डे बाय डे. Right now we are in the stage of weak AI, but eventually we'll reach strong AI and maybe super intelligence. Right now AI uses some help of human. तो first inventor is usually the human. लेकिन जब ये AI अपने आप से ही इस तरह की invention करेगा, then the question arises that who would be the true and first inventor? क्योंकि अभी जो present national regimes हैं या फिर international regimes भी हैं, वो इस problem को address नहीं करते हैं. The next provision is the administrative framework. So the convention establishes a union which has three other organs. First is the assembly, the executive committee, and the International Bureau of WIPO. Article 13 talks about the assembly. Article 14 talks about the executive committee, and Article 15 talks about the International Bureau of WIPO. Paris Convention was first of its kind for the protection of intellectual property, but there were certain drawbacks to it. One such drawback was the absence of universally applicable legal provisions, जिसकी वजह से हर कंट्री अपने अलग डोमेस्टिक लेजिस्लेशंस बना रहा था जो कि यूजुअली स्ट्रिंजेंट नहीं थे, जिसकी वजह से जो डेवलप्ड कंट्रीज थे उनको काफ़ी ज़्यादा इकोनॉमिक लॉस हो रहा था क्योंकि वो अपने नेशनल्स के राइट्स को प्रोटेक्ट नहीं कर पा रहे थे इन अदर jurisdictions. तो इसकी वजह से there was a lot of campaigning and negotiations which led to the formation of World Trade Organizations and the TRIPS Agreement. WTO or the World Trade Organization. It came into force on 1st January 1995. This was the successor of GATT, that is General Agreement on Trade and Tariffs. WTO majorly deals with goods, services, and intellectual property rights. One such agreement of WTO was the TRIPS Agreement, which also came into force on 1st January 1995. It is Agreement on Trade-related Intellectual Property Rights. There are 73 articles under the TRIPS Agreement that is divided into 7 parts. This is the TRIPS Agreement. The part 1 talks about the general provisions and the basic principles. Part 2 talks about standards concerning the availability, scope, and the use of intellectual property rights. It has been subdivided into various property rights like copyright, trademarks, GI, industrial designs, patents, layout designs, protection of undisclosed information or the trade secrets, control of anti-competitive practices, and contractual licenses. So basically, TRIPS provides a minimum level of protection with regard to all these IPRs, and all the member countries have obliged themselves to follow these rules. Part 3 talks about the enforcement of IPRs. It has various criminal procedures and civil and administrative procedures and remedies. Part 4 talks about acquisition and maintenance of IPRs and related inter partes procedure. Part 5 is about dispute prevention and settlement. Part 6 are transitional arrangements, and Part 7 is institutional arrangements and final provisions. Let's look at the basic principles. So Article 1 to 8 talks about the basic principles, out of which Article 3, national treatment, and Article 4 are the bedrock of WTO and the TRIPS Agreement. So Article 3, national treatment. It says that each member shall accord to the nationals of other member treatment no less favorable than the accords of its own nationals with regard to the protection. So we have already discussed national treatment principle under the Paris Convention. There are exceptions over here which states already provided in respectively the Paris Convention, the Berne Convention, the Rome Convention, or the Treaty on Intellectual Property in respect of integrated circuits. Next is Article 4, Most Favored Nation Treatment. It says, with regard to the protection of intellectual property, any advantage, favor, privilege, or immunity granted by a member to the national of any other country shall be accorded immediately and unconditionally to the nationals of all other members. इसका मतलब कि अगर आप किसी और कंट्री को कोई भी एडवांटेज, इम्यूनिटी, फेवर या प्रिविलेज दे रहे हैं तो वो सेम एडवांटेज, इम्यूनिटी, प्रिविलेज आपको बाकी मेंबर कंट्रीज को भी देनी होगी. ये इसलिए है ताकि कोई डिस्क्रिमिनेशन ना हो बिटवीन द मेंबर कंट्रीज, और जो स्मॉलर कंट्रीज है वो भी उन एडवांटेजेस का फायदा ले सके जो कि लार्जर कंट्रीज को दिया जाता है. दिस इज जस्ट टू ensure that there is non-discrimination between the member countries. It also promotes free trade among the countries. Let's look at part 2 of the TRIPS agreement. तो इसके सेक्शन 1 में कॉपीराइट एंड रिलेटेड राइट्स को डिफाइन किया गया है एंड वेरियस प्रोटेक्शन इज गिवन टू देम. Under Article 9, it says that copyright protection shall be extended to expressions and not to ideas, procedures, methods of operation, or mathematical concepts as such. Under Article 10, it says that computer programs, whether in source or object code, shall be protected as literary works under the Berne Convention. So they are given protection under copyright. And various other rights are given under rental rights. Term of protection. So under Article 12, it says that whenever the term of protection of a work other than a photographic work or a work of applied art is calculated on a basis other than the life of a natural person, such term shall be no less than 50 years from the end of a calendar year of authorized publication, or failing such authorized publication within 50 years from the making of the work, 50 years from the end of the calendar year of making. So basically 50 years protection is given to copyrights. Next, moving to trademarks. Article 15 to Article 21 talks about trademarks. Under Article 18, it says that initial registration and each renewal of registration of a trademark shall be for a term of no less than 7 years. The registration of a trademark shall be renewable indefinitely. So for trademarks, the term of protection is 7 years under the TRIPS agreement, and it is renewable indefinitely. Geographical indication is given under Section 3, Article 22 to Article 24. The protection accorded to them is 10 years. Section 4 talks about industrial designs, Article 25 to Article 26. The protection accorded to them is also 10 years, at least 10 years. Next, Section 5 talks about patents. Article 27 to Article 34 talks about patent rights. So under Article 33, the protection is given to be a period of 20 years from the filing date. The Madrid system of international registration of marks. So this system is basically governed by two treaties. First is the Madrid Agreement of 1891, which has been revised 6 times, latest being in Stockholm, 1967, and the Madrid Protocol. The protocol came into force on 1st December 1995. This system is administered by WIPO at Geneva. मैड्रिड एग्रीमेंट आया था फॉर इंटरनेशनल रजिस्ट्रेशन ऑफ मार्क्स. उसके बाद मैड्रिड प्रोटोकॉल आया to make the procedure more compatible with the domestic legislation of other countries and to make it more cost effective. इस प्रोटोकॉल के बाद अब आपको सिर्फ एक ही एप्लीकेशन फाइल करनी होती है विद इन द ओरिजिन. After this protocol, the national can get the trademarks within 18 months of filing a single application from the country of origin, and they have to pay just a single fee for the entire process. Article 2 of the agreement talks about the membership. So it says that if you are the member of Paris Convention, then you can become member of the Madrid Agreement and the Madrid Protocol as well. Then it talks about the intergovernment organizations. So if an intergovernment organization wants to become part of the Madrid system, then it can only become part of the protocol and not the agreement. And that too, there are two conditions. One is that at least one of the member state has to be part of the Paris Convention. And the second condition is that the organization must have a regional office for the registration of the trademarks in the territory of the organization. Article 2 and Article 3 talks about the registration. So under that, you have to present your application to the International Bureau, and the classification is done in accordance with the classification given under the NICE agreement. This agreement talks about the international classification of goods and services for the registration of marks. There are three kinds of application. One is exclusively governed by the agreement, or one is exclusively governed by the protocol, or it could be exclusively governed by both the agreement and the protocol. The fee is also of three types. One is the basic fee, which is for meeting all the expenses of the International Bureau of WIPO. The second is the complimentary fee, जो कि आप पे करते हैं हर डेजिग्नेटेड कॉन्ट्रैक्टिंग पार्टी के लिए जहाँ पे आप ट्रेडमार्क के प्रोटेक्शन के लिए अप्लाई कर रहे हैं. थर्ड इज द इंडिविजुअल फी, जो कि कोई भी कॉन्ट्रैक्टिंग पार्टी अंडर द प्रोटोकॉल उसने ऐसा विश किया है दैट दे वांट टू रिसीव सच इंडिविजुअल फीस. अगर आपकी इंटरनेशनल एप्लीकेशन कंप्लाई करती है विद ऑल द रिक्वायरमेंट्स, तो इंटरनेशनल ब्यूरो उसको रिकॉर्ड कर देगा अंडर द इंटरनेशनल रजिस्टर एंड इट विल पब्लिश इट इन द गैजेट. देन इट विल नोटिफाई ईच ऑफ द कॉन्ट्रैक्टिंग पार्टीज इन विच द रजिस्ट्रेशन इज रिक्वेस्टेड. Each of the contracting parties has the right to refuse to give you the registration. अगर कोई भी contracting party refuse कर देती है, then it has to inform you within 12 months. In the case of Madrid agreement, and in the case of protocol, the time period is 18 months. ये जो refusal है इसको record कर लिया जाएगा under the international register and a copy is given to the international holder of the trademark. Now let's see the term of protection. So the duration of protection is 10 years under the international registration. This registration can be renewed for a further period of 10 years on payment of the prescribed fees. इस मेरिट सिस्टम का ऑब्जेक्टिव और बेनिफिट ये है दैट यू गेट अ इंटरनेशनल रजिस्ट्रेशन. दिस इंटरनेशनल रजिस्ट्रेशन इज इक्विवेलेंट टू अ बंडल ऑफ नेशनल रजिस्ट्रेशंस. तो आपको सिर्फ एक ही एप्लीकेशन से you are getting registration in a number of member countries. So it makes the procedure more flexible and easy to get protection in other jurisdictions. Now let's look at the other important conventions. Now let's look at various other international conventions with regard to other intellectual property rights. So first one is copyright and related rights. So with regard to copyright, there have been many conventions. The first of which was the Berne Convention for the protection of literary and artistic work, 1886. Next was Universal Copyright Conventions. Then came the Geneva Convention, 1971. The Brussels Conventions, Geneva Treaty for the international registration of audio-visual works. Then came the WIPO Copyright Treaty. Then WIPO Performance and Phonograms Treaty 1996, and the most important one, TRIPS Agreement 1994. With regard to trademarks, the Paris Convention 1883, the Madrid Agreement, then there was the protocol that we just discussed, the Nice Agreement, the Vienna Agreement for the international classification, and the TRIPS Agreement. For GI, there was the Lisbon Act and the TRIPS Agreement. Industrial design, there was Hague's Agreement, Locarno Agreement, and the TRIPS Agreement. For patents, Paris Convention 1883, Patent Cooperation Treaty 1970, Budapest Treaty, and there are various others. And finally, the TRIPS Agreement. So these are the major international conventions which came for the protection of the intellectual property rights.